Good morning once again, class. Now today we are going to study about the right to information. Now right to information or RTI has been included in Article 19(1) of the Constitution. Right to information is an implied fundamental right. What does that mean? An implied fundamental right is the one which is a part of a named fundamental right or partakes of the same basic nature and character as that of fundamental right. Partakes means takes from. Since RTI is implicit in the right to freedom of speech and expression, it is an implied fundamental right because if one does not know the facts, one cannot speak freely. The Right to Information Act came into force on October 12, 2005. This act gives the citizens of India the right to a. Seek and receive information from the government and other public authorities, ask them certain questions, take copies including certified copies of documents, inspect documents, take sample of materials. Now any citizen can file an application under RTI with the public information officers, assistant public information officers, and seek the required information. Now this particular right already exists in a lot many Western and other countries. So this is a quite new entrant where Indian Constitution is concerned. So you can seek and receive information from the government. Other than, see over here also there are a lot of limitations. You just cannot ask for anything. If it is a sensitive information in terms of the security, internal or external security of the nation, you will not get that particular information. Ask them certain question, only certain, not all. Okay, take copies. You have the right. See where the funding is taking place, what is the government doing in the education sector. All such normal things you can ask for, but something to do with internal and external security is out of bound for the ordinary citizens of India, because then the security of the nation will be obstructed or hampered, or this particular information can land in the wrong hands. Now let us see over here. Supreme Court declares. Children, see please, this is important. All this you need to know. Right to privacy. What is our right to privacy? It is a fundamental right. On August 24th, 2017, Supreme Court of India declared the right to privacy as a fundamental right. So this is also quite new. Right to privacy. What is it? Let's see. The Supreme Court confirmed that the right to privacy is a fundamental right that does not need to be separately articulated but can be derived from Articles 14, 19 and 21. So right to privacy over here, it has taken up as an individual right, but it is already been mentioned, or it can be taken out from Articles 14, 19 and 21 of the Constitution. It is a fundamental right about all informations of a person and the choice that he makes. It protects an individual from the scrutiny of the state in their home, of their movements and over their reproductive choice of patterns, food habits, etc. Now let us quickly look at this. Protects an individual from the scrutiny of the state. So all of us who are now most of the time online, we are very careful about the kind of information that we are putting up on Facebook or Instagram or any other such social media. And if you have visited a place and your location is turned on in your phone, then immediately you will start getting emails about whether you liked your visit to such a place. So what is that? Your privacy is questioned. Now over here it is, you have no privacy. Everything is known to people, and you know that phones can be hacked, computers can be hacked, and so many different sites can be hacked, and your personal information, your bank accounts, the number of people in your family, your age, and any other private information can become public and people can misuse it. So The state protects an individual from, and see, even the governments of country, if we are talking about communist countries and all, so over there people do not have a number of liberties that people otherwise in a democratic nation enjoy. Now it is not an absolute right, it is subjected to reasonable restrictions. Let us see what they are. The Supreme Court clarified, made clear that the fundamental right to privacy is not absolute and will always be subject to reasonable restrictions. If you are a criminal, then of course the state has a right to know as to where you will be, because you pose a threat to the life and property of the other individuals of the nation. The state can impose restrictions on it to protect legitimate state interest, but it can only do so by following the points given below. Now let us see what they are. Existence of a law that justifies an encroachment on privacy. So there has to be a law that justifies. That justifies means, okay, fine, right, you can do this. Encroachment on, nobody can encroach on your privacy. Nobody can demand that you let the others know about your personal choices. A legitimate, over here, an official or allowed according to rules. State need that ensures the nature of this law falls within the zone of reasonableness and without arbitrary. What does that mean? Not based on reason or evidence or proof, without arbitrary state action. Now, it has to have some reason behind it. The means adopted by the state are proportional. What is proportional? The relationship that exists between two things, okay, in terms of size, quantity or amount, to the objects and needs sought to be fulfilled by the law. So according to the judgment, the legitimate aims of the state should be protecting national security, preventing and investigating crime, encouraging innovation and the spread of knowledge, and preventing the dissipation. What is dissipation, children? Process of slowly disappearing or becoming less. Social welfare benefits. So according to the judgment, which judgment we are talking about? The limitations that it is subjected to reasonable restrictions. The legitimate aims of the state, legitimate means allowed or official, should be to protecting national security. See, it can be internal and external. Preventing and investigating crime. If you are of a criminal nature, then of course you do not have any right to privacy. All your moves will be monitored by the government. And then encouraging innovation and the spread of knowledge. So all these fall under that it is not an absolute right. Now let us learn about what privacy includes. Preservation of personal intimacies, the sanctity of family life, marriage, procreation, home and sexual orientation. What you do within the four walls of your homes is your own choice. The government or no other individual of the nation has the right to encroach upon your privacy. A right to be left alone. You cannot be forced to take part in to be a part of certain institutions or organizations. If you don't want to be, or any political party, if you don't want to be, you have the right to live your life peacefully. Safeguards individual autonomy. What is autonomy over here? The power or right of a state or an individual to govern itself, protecting vital aspects of his or her life. You have the right to live your own life the way you want, on your own terms. The state cannot tell you unless it infringes with the security of the state or other people. Now, personal choices governing a way of life are intrinsic to privacy. Intrinsic, essential or natural, they are a natural part of something. So, your personal choice is a right to privacy. Now, it recognizes plurality and diversity of our culture. Plurality means people people from different regions, they have different languages, culture, traditions, eating habits. So all these, this particular law, it recognizes both the plurality and diversity, and it encourages it. So please, I want you to go through the right to information again, and the right to privacy, which is a fundamental right. Go through it again. If something which is not understood, please rewind the video and try and understand it. If still not possible, then please make a note of it in your textbook or diary, and we will take it up again once the school reopens. Thank you.